Okay, test. Okay, there we go. Half a day. Today is July 30, 2015, and it's 9 a.m. My name is Rosanna Robigo. I'm the Environmental Public Health Officer Administrator with the Division of Environmental Health of the Guam Department of Public Health and Social Services. We welcome you all to this public hearing where we will be accepting and hearing testimonies on the proposed rules and regulations governing the Joaquin Casey Conception the Second Compassionate Cannabis Use Act of 2013. This is day 2 of our public hearing series, if you will, for these rules and regulations. With me today is Mr. Tom Nadeau. He's the Chief Environmental Public Health Officer of the Division of Environmental Health. Mrs. Michelle Lastimosa, Environmental Public Health Officer 3, and Ms. Cynthia Naval, Planner 4 with the Division of Environmental Health. I would also like to acknowledge the presence of our Director, Mr. James Gillen of Public Health, Mr. Brian Siniclas of the Governor's Office, members of the Advisory Board. Thank you for joining us, and senators of Senator Ada and Senator Tina Rose Munoz Barnes with the 33rd Guam Legislature. Thank you for allowing us the use of this room. The promulgation of rules and regulations is governed by the Administrative Adjudication Law, which is Title 5 GCA Chapter 9. And the said law requires that 10 days before the public hearing, a notice must appear in the newspaper of general circulation in Guam announcing the date, time, and place of the public hearing. The department did comply with the provision by publishing the announcement in the Marianas Variety on July 15, 2015. Although it was not required, the department published a second announcement on July 28, 2015. In addition, the notice and the proposed regulations were posted on the department's official website at www.dphss.guam.gov. As part of the Administrative Adjudication Law procedures, it was determined that by the department that these proposed rules and regulations are exempted from the requirements of an economic impact statement because the annual economic impact to the general public will be less than $500,000. The Joaquin Casey Conception the Second Compassionate Use Act of 2013, hereafter referred to as the Act, was passed by voter initiative during the general election of November 4, 2014. Then on February 16, 2015, Acting Governor Raymond S. Tenorio assigned and designated the initiative as Public Law Number 32-237. The Act mandated that the Department of Public Health and Social Services promulgate rules in accordance with the Administrative Adjudication Law procedures for its implementation. So in conformance with the Act, the Department drafted these proposed rules and regulations to address the following. Number 1, govern the manner that applications for registry identification cards and the renewal of identification cards for qualified patients and designated caregivers will be considered. Number 2, define the amount of cannabis that is necessary to constitute an adequate supply, including amounts for topical treatments. Number 3, identify criteria and procedures for including additional medical conditions, medical treatments, or diseases to the existing list of debilitating medical conditions. 4, identify requirements and associated fees for the licensure of producers and cannabis production facilities and the procedures to obtain licenses. 5, develop a distribution system for medical cannabis. 6, determine additional duties and responsibilities of the advisory board. And 7, set application fees for registry identification cards so to defray the administrative costs of implementing the Act. 4 stakeholder meetings were held to address any concerns by affected Government of Guam agencies, healthcare entities, law enforcement agencies, and banking, financial, and health insurance organizations during May and June of this year. The minutes of these stakeholder meetings will be available to the Guam Legislature as part of the Administrative Adjudication Law process. For purposes of this Act and these proposed rules and regulations, the Department intends to treat medical marijuana for its intended purpose, as a compassionate medication to treat those with identified debilitating medical conditions. The Act clearly defined the Department's roles and responsibilities in implementing the Act. It is important to note that there are several issues relating to medical marijuana that are not addressed in these proposed rules and regulations, simply because they lie outside the jurisdiction, the scope, or the authority of the Department of Public Health and Social Services. We have scheduled 3 public hearings. The first one we held yesterday. This is the second one. And we are holding it to receive the input and comments of the public on the proposed rules and regulations. Upon the conclusion of these hearings, the department will review all received testimonies and make changes to the proposal if necessary before it is transmitted to the Office of the Attorney General for their legal review, as required in the Administrative Adjudication Law. After the department receives the review and approval of the Attorney General, the finalized draft proposal will be provided to the governor for his review and onward transmittal to the 33rd Guam Legislature for adoption. Given the time constraint of 2 hours for today's hearing, we ask for the cooperation once again for everyone in understanding that those in attendance will be providing oral testimonies. We ask that the comments be specific to the draft proposal. We are requesting that testimonies be limited to no more than 10 minutes if possible, just to allow everybody time to present. If a presenter believes that more time is needed, we recommend that written testimony be submitted. The department wishes to give everyone ample time to give their testimony. However, in the event that we run out of time today, you also have an opportunity to present tomorrow, July 30th. Tomorrow's hearing will be held at the Division of Senior Citizens Conference Room, located at the Castle Mall building in Manilao, from 3 p.m. to 6 p.m. Written testimonies can still be submitted to the Division of Environmental Health up to 10 calendar days after this Friday's public hearing. Before we begin, I would like to request that all cell phones, and if anyone's still carrying pagers, be placed on silent mode. Restroom facilities are located right outside the door to the right. And lastly, please be advised that this session's public hearing will be recorded and televised. We will now formally accept any written or oral testimonies on the proposed rules and regulations governing the Joaquin K.C. Concepcion II Compassionate Cannabis Use Act of 2013. And we will begin by calling 4 individuals at a time as listed in the sign-in sheet. Dankuluna si Zeus Maasi. The first 4 individuals, we would like to call them up to the table. And as everybody presents their oral testimony, can you please state for the record your name, and if the mic is not on, please turn on the button right in the middle of the mic. Jesse Pablo, Andrea Pelicani, Janine Sablan, and Mo Cotton. Can you please come up to the table?
Hi, my name is Jesse Pablo, and I'm actually not a resident of Guam. I'm actually a resident of Washington State. I'm a medical marijuana patient from there, and after finding out more about Guam and finally voting this program in, I've been following a lot of the authoring of this draft, and from what I see, it seems too much of a bureaucratic function. In Washington State, we have the ability, as a medical marijuana patient, to cultivate up to 15 plants, and We can start a collective among up to 4 people or more to 60 plants total. And that gives every patient the ability to work with the dispensaries in order to sell their products. And the thing about that is it gives a lot more options for the patients. They have an understanding of this industry, and when you have all those choices, the quality goes up and the prices tend to go down. And my feeling about having a bureaucratic function manages is that it's going to cost too much for the patient. Director Gillen was quoted saying before that there'd probably be a price point of $500 per ounce for Guam medical marijuana patients, and I just don't feel that that would be an affordable price point, given that in Washington, Oregon, California, the price average is around $150 to $200, and according to the Bureau of Labor and Statistics, Guam's annual income is about 30 to 35% less than those states. So to me, it doesn't seem like it would be something that's sustainable for Guam Public Health and the government to maintain this. The way that we have it over there is that we have the patients being a participant of this industry. We have basically a figure that authorizes the cards, and a lot of times that's not the an actual MD. They're naturopath doctors. It's kind of a conflict of interest for an MD to prescribe marijuana, because they make a lot of their living off of prescribing drugs, over-the-counter drugs. And so, I don't see a lot of the MDs being able to approve this marijuana for patients as much as a naturopath doctor would. The other issues that I see in this is that it costs money to manage this type of program, even though Director Gillen is getting this from Arizona State. The director of that program is now gone, and so as he goes away, the tribal knowledge for this type of program is not there. So if the program has any bugs or any issues with it, it could compromise the security, and there could be an outage, and so that might prevent patients from actually accessing their medicines. So that's some of the things that need to be considered is that this is going to be a costly function for the government of Guam, and I'm not so sure that people are going to be willing to participate in this type of program. They're more than likely they're going to probably seek the underground or black market to seek their medical marijuana, and that's not a good thing, because a lot of times when marijuana is associated with the black market, they tend to push the other bad drugs because there's higher margins on those. Marijuana, there's a science behind it. It's resource intensive to grow the plants, but a lot of the people who have the other drugs, tend to push those more because it's cheaper to have those. So, in my opinion, I feel that Guam has an opportunity to work with even the Asian continent. I know that there was discussion of including Japan medical patients. Is that true? And that's income that I think Guam should consider, because it would add outside money into the economy of Guam. And I know that you had just stated just before that the economics of this is not considered in drafting this proposal. So I think that Guam ought to consider allowing Asians to come, because we have multiple flights coming over here to Guam, and that would allow more income to come to Guam, and it'd help offset your guys's, I guess your debt, and that it'll create more income. There'll be a lot more. There'll be more competition. There'll be more quality if you get more players involved in this type of industry. But as far as what I see from the panel, it's like, there's a lot of, ignorance. I'm not trying to be, mean about it, but it's just that I feel that more people that have experience in this industry would add a lot more value to it, and it'd be a good thing for medical marijuana patients. Anyway, that's all I have.
Once again, just for the record, I'd like to state that there is nothing in the regulations, current rules and regulations, that placed a cost for the price of marijuana. The $500 you mentioned, Grant, it's been mentioned in the past publicly by our director, but at the same time he commented that's a hypothetical situation, possibly extreme end of the cost of marijuana may be. It may be lower.
Okay.
In fact, as I mentioned, we believe the market may set that price, which we have no idea what that will be. So it's very possible it may be $500, but also maybe extremely less. We are not certain, and we suspect the market will decide what that cost will be. Okay, so I just want to put that in mention.
The amount would be when you're paying the 500 or 300. You're getting one cigarette, or are you getting what are you getting for that?
That's just that we are not certain how much will be charged. That market will dictate that.
I know you don't know what's going to be charged, but let's say you do know. How much marijuana would you get? A week supply?
Okay. Well,
2
first of
weeks
all,
supply?
yeah, let's do this, sir.
Let's have you on the record who you are, identify yourself, then ask the question.
I'll wait till.
Hafidin, good morning. I'm afraid I may exceed my 10 minutes, so if you can bear with me. We have a point-by-point analysis on the draft rules, and so I would really like to get through all our points if possible. If we can exceed that 10 minutes, I think we might go, I'm pretty sure we're going to go over 12 and a half. Anyways, good morning, and thank you for the opportunity to speak with you today. My name is Andrea Pellicani, and this is Janine Sablan. We are from the organization Guam Grassroots. Not present today. She's off island, is our other partner, Genevieve Oka. Our mission is to provide education and outreach to patients in the community about the benefits of cannabis therapy. The best advocacy is done by those who are affected, and so policy should be patient-driven and not government-driven. In the interest of full disclosure, we are looking to procure licensing in the medical cannabis industry here on Guam. For the past year, we have been doing research, meeting with cultivators, dispensary owners, processors, brokers, and advocates, and also networked with consultants in the cannabis industry across the nation. Through this, we have gained much knowledge regarding different types of therapies for different types of ailments. Science has yet to catch up to the industry due to strict guidelines by the federal government. Medical cannabis should be viewed as herbal therapy. What this means is that patients who are legally authorized to participate in their programs are in charge of managing their symptoms and treatments and empowering them to make choices about what they put in their bodies, be it Western medicine or herbal therapy. As patients, we have the right to refuse or accept any treatment or look toward alternative therapy options. There are many studies out there that show statistics regarding decreasing in underage use, decreases in crime, decreases in deaths due to prescription pain medicine as a direct result of flourishing legal cannabis markets. It's up to us as a community to see what mistakes other states have made and not to reinvent the wheel, but to learn from them. Providing patients with safe and affordable herbal therapy is our main goal. As we review the draft rules and regulations, we found many areas where we think we could make a difference, and that is why we are here today. While we feel that sensible regulations are necessary, over-regulating does not allow the industry to flourish, discourages patients from participating, and does not impact the black market negatively. The draft rules are very thorough with regards to policing the businesses, doctors, and patients participating in the program. However, there are many areas where there's little to no language regarding items such as environmental wastewater handling, agricultural guidelines, proper labeling guidelines, quality control guidelines, proper cannabis handling, etc. We have a printed copy of our analysis as we go through point by point. You can follow along. We have associates that we work with stateside. They helped us prepare our analysis, and they are Comprehensive Cannabis Consulting, and they are based out of Colorado. Their bio is on the first page. We won't read through that. You can look at that at another time so you can see what their qualifications are. You can also visit their website. Can we open by section? We'd like to start with section 14101 in the definition section. This part of the definition, the part of the definition of a designated caregiver is subjective and should be removed as the patient is already designated by the patient to be their primary caregiver. So making it a qualification that they hold significant responsibility for someone's care, I don't know that they can prove that. The patient is already designating them, so we think that is a unnecessary qualification. And we would like that section removed. Section 14102A-1-2 in the fees section. The $35,000 initial and annual licensing fees for dispensaries and cultivation sites is likely too high, as Guam's population implies a fairly small medical cannabis market. Such fees may have the effect of raising prices for medical cannabis out of the reach of some patients. For reference, Colorado's fee schedule is much less burdensome, even though operations can expect greater revenue than those in Guam due to the fairly large market. 2% of Colorado's population holds medical cannabis cards, roughly 115,000 cardholders amongst 5,356 million residents. By comparison, this would equate to a patient population on Guam of roughly 3,300 patients, 2% of 165,124 residents. It must also be noted that our requirements are much more strict than Colorado. Article 14102, we recommend that the line an applicant submitting an application to the department shall submit the following non-refundable fees should be revised and clarified. The section does not include the application fee of $1,000 for those applying for dispensary or cultivation licenses, as noted in Article 14107 F1D on page 35, that it's not listed anywhere under the fees. It just kind of popped on that page, but wasn't listed under the fees. So our concern is that the language is unclear. If you turn in an application, do you have to pay $35,000 that's non-refundable on the... I mean, what if I don't get approved? I can't get my $35,000 back? We think that language is unclear. If that is not the intention, we think that it should be clarified. Can you clarify how the fee schedule works? There's no flow chart. I was hoping to get a flow chart for this particular section at the front.
Maybe we'll go through the two things that you talked about, including the designation or the definition of the designated caregiver.
Okay.
And the reason we put that caveat, that they had to be responsible for the patient is because what we learned was that there could be fraudulent caregivers. If someone is sick and has a debilitating medical condition, there could be somebody unknown to that patient who might approach them and say, "Oh, I'll take care of you. I'll I'll, help you fill out your application. I could be your designated caregiver. I can pick up your medication for you, and that's an avenue for diversion. So there has to be that protection that that person acknowledges, and he attests that I'm going to be responsible for this patient. That, if there's diversion or if there's fraudulent or illegal activity or...
Then their cards would be revoked.
Right, but that has to be put in there, that they acknowledge that that's their responsibility, that they're not doing it fraudulently, that they're going to do it.
And they should sign a statement saying that they're responsible.
And that's
I just think that having to prove you have a certain amount of care for another person is impossible to prove. Mm-hmm. There's no ranking, rating. I may be caring for my sister, but my child may be more appropriate because he may be younger, have a vehicle, maybe I don't have a vehicle, to be their caregiver for this program,
right.
As opposed to myself.
Right, but it's much, if you can relate it to like in a court system where you're being appointed a custodian, that you're understanding what your responsibilities are in that capacity.
But the responsibilities and guidelines are clear. Are you to watch this person from this time to this time? This is just subjective. I believe it's just subjective. If you want to make it clear, does it have to be a familial relation? And then, if they're signing a statement that they're responsible, that they're signing a statement that says they're not going to divert any of the that this becomes unnecessary. It's just redundancy. It's bureaucracy. It's unnecessary. They're signing a statement they're not diverting, right? When they go in to apply as a designated caregiver.
Right. But I think just to be overly cautious that the rules and regs identify and clearly state what it means to be a designated caregiver. We can assume, like, oh, I'm your primary caregiver, and we all can understand what that means to take care of somebody. But, if it ever came down to a legal interpretation, that person needs to know what their responsibilities are, and that's all we're trying to do to...
And I understand that, but the legal interpretation is that clause right there specifically is subjective to every different person, to the clerk taking your application. What is a significant responsibility for another human being? It's not... There is no, it's subjective, depending on the person who's hearing it. And when we think it's just unnecessary as a qualification to be a caregiver.
Okay, we're certainly open to language.
Yeah. Thank you so much. And then the fees, right?
And then for the fees, again, as Tom had mentioned yesterday, that everything is about the government being able to operate this program. And then when we did a cost analysis of what it's going to take to run this program, that $35,000 didn't even cover the cost of government operations to run the program. So whether or not it's a large population or a small population like Guam, the infrastructure, the personnel, the manpower, the supplies and equipment are still the same as if
I understand that, but that's not the patient's responsibility to pay for the program that the government implemented.
Right, and it's not borne by the patient. It's borne by the company that wants to make a profit off of...
Which will be passed on to the cost of doing business, as a cost of doing business.
Right.
The cost for me to open a cultivation site and dispensary is going to cost me $70,000 just to apply. How many pounds of medicine do I have to cover just to pay for the licensing? That doesn't account for infrastructure, security, compliance, and all the other costs that businesses will have to shoulder the burden for. All those costs get put into the cost of the medicine, raising the cost of the patient. That's just kind of business 101. And so when the cost to operate, just to get a registration certificate is, if I want to do both, is $70,000. That's an awful lot of money for a 3,000 patient base. If we're only looking at 3,000 eligible patients, divide that $70,000 up to realistically how many patients are going to sign up for this program, maybe 15%, maybe 20%, at cost, that cost is going to get extended to them. These are patients who have spent their life savings on cancer therapy and are looking for something else because, chemotherapy is killing their good cells. They may have done research and may want to try hemp oil that has anecdotally been shown to help shrink tumors. This is their a lot of times, this is their last ditch effort to stay alive. And you want us to pass the cost of $70,000 onto a $3,000, it just economically doesn't make any sense.
I think we could possibly help with your question by, we did analysis for the cost to run the program itself and also the cost to, assuming that all 3,000 some people participate. But while she's looking that up, we're going to take a couple-minute recess to allow her to access that information.
Sure.
Is that right? So is it all right if we take a couple-minute recess? Thank you very much. So we'll take a recess for a couple of minutes. So I thank everyone's patience. If you're ever going to just stay around, that'll be great. Thank you.